We were in the middle of our tournament when my friend John said he found a body in the bushes over there. I ran over there because I'm a healing monk to try and help, but obviously my magic wasn't strong enough because the dude's body was missing a head. So my friend decided to try and use a necromancer spell, which didn't work, which I knew it wouldn't. And apparently we contaminated the crime scene because that spell uses a lot of glitter.
Your Honor, I object!
And why is that, Mr. Reed?
Because it's devastating to my case!
I gotta tell you, you brighten my day, ma'am. All right?
That's what the last guy said, and then he sued me.
Hey, good morning. What's happening, everybody? Happy Sunday. I am so freaking stinking excited for today, guys. Come with me and you'll be in a world of legal education. It's going to be such a good time. We've got two amazing guests coming on. Hello, Only Fan. Good morning, Dickie. Amy, so glad to see you. Good morning, Nikki. There you are, Amy. Sorry, sometimes the chat moves right as I'm clicking on something. Nikki is here at the ass crack of dawn, guys, for Washington State. So thank you so much for rolling out of bed super early for all of us. Good morning, Larry. So glad to see you. Colleen is here. Love, mama. We've got Ruby in the house. Good morning, good morning, good morning. I love that. I love that, Dickie. So, hello, Amy Austin. So glad to see you. So guys, we've got two amazing guests. I'm not gonna bullshit so much up here beforehand. We're just gonna get right to it. So first, I'm going to welcome back to the Brit Happens channel an extremely special guest. He is an attorney out of the New England area. You may know him from his YouTube show, About the Law with Andrew D. Myers. Law Offices of Andrew D. Myers is the handle for his channel. If you do not know him, you might also know him because he kicked your ass in court, either in New Hampshire or in Massachusetts, because he is a member of the Massachusetts bar. So please show all the love in the chat for attorney Andrew Myers. Good morning. Welcome back. It is so good to have you on.
Thank you. Good to see you again.
Great to see you. And then my next guest is a first timer here on the Brit Happens show. She has been making a huge splash in the free Karen Reed community. She is a medical attorney out of New Jersey. She also recently accomplished the insurmountable task of losing 150 pounds. Wow. She is Nan-tastic. She is the moment. She is the legend. She is attorney Nan Gallagher. Please welcome Nan here in the chat, guys.
Thank you so much for having me, Britt. And it's very nice to see you, Andrew. Looking forward to this morning's panel.
Nice to meet you too.
I'm very excited. Yes. I'm so glad to have both of you on. We were kind of talking about this in the green room, but guys, the Officer John O'Keefe, Karen Reed case is kind of a unique case. It encompasses so many different categories of expertise here. So having someone like Nan, who is a medical attorney, so she represents doctors in criminal cases, in civil litigations, in malpractice suits, all kinds of different court
proceedings.
Yes, all kinds of different court instances and proceedings. And we've got Andrew, who is specifically a member of the bar in Massachusetts. So he's got some very unique knowledge as well. So I love the elements that you guys each bring to this case. I'm so appreciative of the time that you guys not just put here on this channel, but that you guys are sharing your knowledge with everybody on this case. all over the world, all over the internet. So I'm so glad y'all are sharing all this with us because there's so much to take in. It's too much for one brain with this case.
It's a crazy case.
It is. So for each of you guys, what would you say? Oh, thank you so much, Thomas. What would y'all say is the one detail that brought you on to Karen Reed? What hooked you in? I'll start.
I'm gonna always let Andrew start first because he's really at ground zero there. So that way we try not to interrupt each other. So the floor is all yours.
Oh, wow. Well, thank you for giving me time to think because you kind of stumped me on that. I think I would say that it is local news here. I mean, Canton, Massachusetts is just south of Boston. I live north of Boston, but so when it originally happened, the headline was, girlfriend kills boyfriend, Boston cop. That was basically the way they portrayed it. And then as time went on, I listened to a local radio show and that guy named Turtle Boy was on. And I thought the guy was crazy. But the more I listened, that while people might say that he's crazy and he's done some things that are questionable, he was right on point about a lot of the questions that he was raising about this case. And so I picked up the Boston Magazine article that was written by Gretchen Voss. It's a great magazine. It comes up in my feed. And I read that article. And I have a late friend who was in the Boston media who used to help me with this podcast. And unfortunately, he's passed away. But we read that article and we started discussing it. And we didn't agree. And as we have been ever since we've known each other for decades, we started arguing about the case. So that's what drew me in. And so listening and then watching the trial and just what a train wreck. That's the nicest thing I can say about that trial was that it was a train wreck. From beginning, middle to the inverted video to the end. It just, so I was, I've been drawn in kind of since the beginning, but my thoughts have kind of gone all over the place.
Oh, that's great. I figured your introduction into this dumpster fire, to quote AJ, of a case really had a lot to do with the fact that being that the issues are so local and also so societal up there that and given your background both in reporting and in law and being geographically just so grounded there, I knew that was really what drew you in. And just so everyone knows, I've actually been, I won't say a fan, Andrew, but I've been a spectator. I am a fan, but there are other creators who I have followed also, in addition to you, for gosh, it's been almost 2 years now. And as an attorney practicing in healthcare law from New Jersey for approximately 25 years, doing things like civil, administrative, and criminal defense. And I do some civil plaintiffs work as well in the form of civil rights actions. Mm-hmm. I had been following this case as a true crime aficionado and just got dragged in very early on. Also, as did you, from some of the reporting of Aidan Carney. I make no secret of it. Like, I feel like his writing is superb. As an English major, I just was very drawn to it. And I knew that a lot of what he was uncovering, I know he's not afraid to put disruptive facts out there. If he has sources, he puts them out there. So that drew me in. And then, as Britt mentioned, I figure I'll address the pink elephant in the corner. I felt I had to put out on social media yesterday because there are some trolls out there who have not liked my outspokenness on the Free Karen Reed movement, which is where I fall just because of how I'm reading the law, seeing the facts, and all of the above. I watched the trial gavel to gavel and the content creators, but a lot of people have been on the other side criticizing me because of some fluffier pictures in my days of carrying some excess weight that have been online, and some videos out there, which are incredibly boring videos. If anyone wants to watch about HIPAA compliance or human trafficking in medical offices, I dare you to go on YouTube and find them. They're scintillating. But anyway, over 2 years, I worked out aggressively while watching and listening to the YouTube content creators, specifically on Karen Reed. And I'm happy to say I did drop 150 pounds, and I've now made weight.
Congrats. Congratulations.
I've now made weight so I can help join the battle that the Reed family faces. And I dare say her team, because a lot of the rulings that have come out and evidentiary challenges and all that I'm sure we're going to discuss, they need all the help they can get. So I'm happy to throw opinions.
100%. And you're obviously not the only attorney who sees all these irregularities in this case. I mean, even Robert Alessi, he saw what was going on and thought, how can I help? And offered his services pro bono. In a lot of ways, both of you are doing the same.
Yes, and Mark Betterow, who is, and I know you've interviewed him, met with him, Andrew. Mark Betterow, also a New York attorney like myself. I'm also licensed in New Jersey and DC. Mark Betterow has spoken up. Alessi has joined the ranks, and I did hear he's serving pro bono. I don't know if that's verified, but kudos to him. For those of you who don't realize this, and I'm sure Andrew would agree, when an attorney provides services pro bono, it's not just I'm giving you services for free. And I find his services to be exceptional from what I can observe, right, Andrew? But also
outstanding. I just can't believe the precision with which he argues, the way he cuts up the arguments of the crazy prosecution. He just orchestrates it so well. When I was watching one aspect of the hearing with regard to whether or not Richard Green was going to be allowed to testify, Hank Brennan really wailed on Richard Green, and it really tore him apart. And I'm saying to myself, this is not good for Richard Green. He's making him sound like a buffoon. What can Robert Alessi say? Well, Robert Alessi got up and he said, okay, let's start from the beginning. And he just took it point by point, logically, reasonably, step by step by step. And that's the precision with which a surgeon approaches his work. And it just blew me away to watch. And he's done that in other cases, but I'm just thinking that is an outstanding example of the work that Mr. Alessi has done. I'd never heard of the guy. He's
I'm sorry, Andrew, I hadn't either, but you're right. And he also he's tackling these complex issues that I'm sure you and I can agree. Like, I don't know if I could easily and fluidly make some of these arguments. And then I wanted just everyone to know that when an attorney gives of their time pro bono, they're foregoing other billable work. So it's not just I'm giving my time for free to Karen Reed's defense. He's, we can't clone ourselves. Don't we wish we could, Andrew? We can't. So he's also foregoing other work. And I've been so impressed. I think he's a really great add to the team, and also very impressed with Alan Jackson and David Yannetti.
Yeah, they're great lawyers. She has a really good team. She has an excellent team. And she had a really good appellate team when they had to go to the Massachusetts Supreme Judicial Court. So she's got a great team. It's just amazing that some of the things that have happened. And I think we're all waiting for the next shoe to drop with the next motion to dismiss, which is pending, as we say now. They haven't filed it now. They just got an extension. They were supposed to file it on February 11th. Now they have until February 21st. But I mean, they, footnote of that previous motion, they said, we're going to bring a motion to dismiss for, outrageous governmental misconduct. So I'm so
excited for that motion, guys. Like, just so y'all know, I took the day off work, and I'm going to go ahead and announce it now. Nan will be returning to this show on Friday. Is it the 21st now? Yep. Yeah, 21st, so Friday the 21st. I've taken the day off of work, and Nan will be joining me again, and we're going to go through this motion because it is going to be elegant. It is going to, as you mentioned, Andrew, be surgical, and it's going to be one of the most beautiful pieces of legal literature that I think we will see in our lifetime. So
But let me just
excited.
point out that if they have until the 21st, we file everything electronically in Massachusetts. So how do you know they're going to do it during the day? They can file it at any time before 11:59
That's right.
at night. So I wouldn't take the day off. I mean, we record our podcast. Dirty little secret: we record our podcast on a Friday afternoon. So I would like it if they would have it done before we record our podcast on Friday afternoon. But if I'm given a deadline, I've waited until 4:59 in the afternoon to file it.
And Britt, when you were asking me, I think it was yesterday about the 21st, I didn't correlate that that's the deadline for the motion to be filed. But Andrew is absolutely right. So I'm very available.
Got it.
At any point to give insights. And I mean, this motion is going to be, as Alan referred to it as, full-throated. But I did want to comment because I really wanted to get Andrew's take on it. The defense team has kind of said, we don't want to be doing this piecemeal. It's hard to be doing that. We just got, in addition, a voluminous discovery dump. And I have taken the position on streams and on social media that many times arguments and motions, whether a motion to dismiss or something else, they all dovetail together. And you don't want to waive certain arguments in filing pieces of a motion. Like when Judge Cannoni kind of said, well, we'll handle them as they come or one at a time. I forget, I'm paraphrasing her, but I found that a little frustrating. And I also have found that, and Andrew, you should know this about me, I find that the April 1st deadline or for the trial date is a little bit arbitrary in my mind. And I actually don't think it will go forward that day. But because I view the April 1st trial date as a little bit arbitrary, I find it bothersome to me, respectfully, when the judge says, I'm not moving that and I want those motion papers in as soon as possible, also giving Hank Brennan a short turnaround time as well to oppose it. What were your thoughts on that?
Well, anything would have been arbitrary. I mean, and remember, initially the trial was set for January 27th. And, that obviously wasn't going to happen. As soon as Mr. Brennan came on the case, I mean, he said, I'll observe the deadlines. If I can't get my experts in, I think his direct quote was, I won't use that expert. But it became obvious that he was going to file a lot of motions. And so the thing had to be pushed back to the arbitrary date of April 1st. But what I find interesting is that when Mr. Brennan was filing motions, the court was happy to push things back. Now that the defense wants to file motions, oh no, we're going to stick to that April 1st deadline, which may be arbitrary. What isn't arbitrary? I mean, they've got to pick a date. When we have a case in Massachusetts, we're giving a tracking order and we're expected to live by it, but they can be pushed back. So my take on it is I think, and I said this on one of my episodes that dropped this weekend, no matter what you think about Judge Cannoni, no matter what you think about her, I'm a member of the Massachusetts Bar. I'm not going to say anything negative or derogatory about a member of the sitting bench in Massachusetts because I have cases pending in the Superior Court. At the same time, if I were her, I would want to get this off my desk as soon as possible. I know there's creators out there who are attorneys in other states who have said, I think these Brady violations and other things are going to push the trial back. No, I hate to disagree with you, Nan, but I'd put my money on the trial going on April 1st. I might be wrong. I've been wrong in the past. I'd put my money on, Judge Cannoni wanting this trial to go forward and get it off her desk and move on to the other stuff that she has.
But the SJC ruling might affect that. But if I'm wrong, I'll buy you a Coke. We'll agree.
I don't drink Coke.
Whatever you want.
Coffee.
Fill in
the
your
stakes
beverage.
are high.
Stakes are really high here. Well, I'm not a betting man, but I just think that she would like to get this thing off of her desk. It's been a real albatross. I mean, I have been open about not agreeing with many of the decisions that have been made, but it can't be any fun to be a judge of this case.
I agree. I was saying a couple days ago, they all kind of want out of the case. We know Karen does, and I have to presume the Commonwealth does. And in my opinion, I think they want out of this case no matter how it resolves, because this is it's a burden on everybody. And certainly I heard your comments on your stream this weekend too. Yes, Judge Canoni definitely would like to wrap this up quickly.
I would think so, yeah.
As quickly as one could perceive it to be. It's been years at this point.
And my take on the motion to dismiss is that it's going to be denied. It'll be grounds for appeal. Certainly, there are a lot of serious issues. There are many, many, many serious issues that Attorney Jackson has alluded to in his arguments on this motion for costs, which incorrectly was denied, in my opinion. But he alluded to a lot of the serious issues. What about this video? That is crazy. How can we be, all of these years, 3 years later, and the original entire video has not been produced? It's been produced, as I said on my episode, of Snips and Snails and Puppy Dogs Tales.
Yeah.
I've had the experience of doing a day in the life video or doing some other kind of a video for one of my civil trials, and the other side wants to see the outtakes. They want to see the whole thing, and they're entitled to it. I mean, we fight. At first we used to fight, but now there's some case law that alleges that. But how can we be this far along in the case and, oh, guess what? There's new video that shows Brian Higgins outside at in the middle of the night talking on his cell phone at the Canton Police Department. How can that be? How can there be new video of the Lexus backing into the Sally Port in Canton? How can there be this new discovery, which I found just really shocking, that some now retired detective in Canton actually on his own, he was a detective, he downloaded the entire video into his own, private iCloud account, and my question is, that's really interesting. Why does a detective in the Canton Police Department not trust the other people in the department and not trust the Norfolk County District Attorney's Office and not trust the Massachusetts Attorney General, so that he has to privately, secretly download this full video into his own private iCloud account? And why isn't, as I said on my channel, I would have, if I were in the defense team, I would have immediately, and no sooner than that and no later than that, while I was in court, I would have drafted up a discovery demand for that video immediately, now, not tomorrow, now.
I agree with you. By the way, Britt, apparently we're not going to let you say a single word this morning.
Oh,
You were great.
No.
No, I knew what I was getting into. I'm having two lawyers on the stream.
I could talk to Andrew and you all day long, but on that note, Andrew, also, from my experience on criminal cases, I even have had judges immediately convene plenary hearings where they're like, hold on a second, you're saying this, you're saying that, both with Jackson saying one thing about the expert coming out from Arizona to look at the video system, etc., and Hank saying one thing, and then it ended up being a costly trip for Ms. Reed. There was also I see how it wasn't part of his motion in terms of what he was seeking in terms of the fees. He wanted a reimbursement of the expenses for that expert's trip. Started to pepper in Brady-related issues, which I think was a very good idea to set the table. But from my experience, judges will say, I want an immediate hearing. What is this going on with video being produced with Brian Higgins in the middle of the night? We did have private testimony where he said this. Or how about the fact that there apparently was a video produced from what I am understanding, July after the trial. There was something produced thereafter recently.
I mean, there's still stuff coming out today. It's insane.
Right. And
why
now
wouldn't she want to get to the bottom of this?
Right. And that's where I feel like the April 1st trial date is, I say arbitrary, but I feel like there's some critical issues here in terms of the veracity and chain of custody, and just this late production of evidence that probably, I mean, I think it was, but if you give the prosecution the benefit of the doubt, probably should have been produced earlier. I look at all of it and say a judge should have held a hearing on these key evidentiary issues, which was why I was surprised that when the judge asked Alan Jackson and Hank Brennan at the hearing on Thursday. Do either of you anticipate filing evidentiary motions? And both of them said no. So I understand there's a motion to dismiss coming and an opposition to it. But from my parts, we would say, oh, yeah, we're definitely filing evidentiary motions on this stuff.
Well, one thing I would say with that is, wasn't it the same exact day that the discovery that even Hank described as voluminous? I mean, it was in excess of 3,000 pages, had just been turned over, with giving the defense, by the way, at the time, February 11th was the deadline. Correct me if I'm wrong in the chat, guys, but February 11th was the deadline for all evidentiary motions.
Yes.
So that would have given the defense, with travel time, might I add, Alan Jackson still has to fly back and forth to California. So 4 days to pour through all that discovery with new experts, new actual factual evidence as well, probably somewhere in there. Probably more videos, might I add. So why is it that they weren't anticipating more evidentiary motions? I don't know.
Did that irk you a little bit, Andrew, when you heard them say no evidentiary motions envisioned, or did that was that of a no moment to you?
Well, I think that they'll bring in last minute motions. I mean, I've always seen last minute motions. All you need to do is state, good grounds for it. And if they say, well, in these 3,000 pages, we discovered there's newly discovered evidence. And so we've stated reasonable grounds. And there, even though she wants to hear motions in limine and things like that in advance, there's always more motions before and during the trial. So I think those are deadlines. But I mean, if there's newly discovered, everything irks me, by the way, if I'm given a deadline. I'm the kid that always waited until the last minute to write my paper the night before it was due. And I think a lot of trial attorneys do the same thing. But if there's new evidence in this 3,000 pages, I'm sure they'll be allowed to argue it later.
I hope so.
Don't you think? I've always found that.
I do, but having seen, and these are my observations, my opinions, and I'm not barred in Massachusetts. Having seen Judge Cannoni in action, I have found her judicial temperament to be one of slight annoyance when there are issues that have popped up once a jury has been sworn and jeopardy has attached. So then it becomes like use the inverted video as an example. And I'm not even saying she did it in this specific example, but that it was an evidentiary issue and a big one that popped up. So
well, I can't really comment on that because that issue was resolved at sidebar and none of us know what that discussion was. That I don't necessarily agree with the ruling doesn't mean that I'm not going to comment on the demeanor of the judge, but that we don't know what happened at that sidebar. I think just because that came in and it was a surprise and it was a shock and it was wrong. And as Attorney Betterow has said, if that happened in New York, that would have been grounds for an immediate mistrial. But once you have a jury impaneled, you know what it takes to impanel a jury. It's a megillah. It's a lot of work. It takes a lot of time. It's a lot of stress. And once you have that jury impaneled, everything changes. And so she just wanted to get the thing going. She wanted to get the thing done.
Yeah.
So
where I feel like prior to jury impanelment, to resolve like critical issues, taking the time necessary to do it is important. That way you're not bothering a jury, you're not inconveniencing people's jobs and lives. And it's probably a cost-saving measure for both the state and the defendant. So I think though we align very much. In my first time talking to you here, Andrew, I feel like I talked to you through your podcast. So
thank you.
I'm looking forward to even digging further into this case during Britt's podcast this morning.
Thank you.
It'll be fun. Very quick announcement. This is an itty bitty baby channel. It's barely over a month old. And we got our very first super chat this morning.
All right.
So thank you,
Congratulations.
Thomas Autonomous Anonymous. Love that handle, by the way. Very, very fun. He says it is now the weight of the Commonwealth versus the weight of Karen Reed's global support. We've got the gravitas. We ain't got no quit, and we got this. A to the men, Thomas. Thank you so much. Guys, if you would like to support the channel, since it is so new and this channel has a lot of bills, believe me, there are means and methods scrolling below at which you can do that. And we did, as of today, open up our ability for the soupy stickers and the soupy chats. So thank you guys so much for just being here, and thank you in advance for all your support, so that this channel can keep channeling and having awesome attorneys like Nantastic Nan and the amazing attorney Andrew Myers. So
Amazing.
yes. So speaking of the jury, how do you guys feel about this extremely difficult task of finding unbiased jurors at this point?
Go for it, Andrew.
Oh boy. Well, I have two thoughts. First of all, we all, even though Boston's a big media, there are 3 or 4 schools that teach nothing but media in Boston. I went to one of them undergrad, and it's a big media city. You would be shocked at the number of people that don't follow the news. We all do, because we read. You're an attorney, you're a podcaster, and you're very much up on issues. When I was a reporter, they would send us out to do, we called them man in the street interviews, but now we're a little bit more enlightened and we call them person in the street interviews. You would be surprised by the number of people who don't even know who the governor of their state is. So we all overestimate that people are up on the issues. I have to be really careful with my words here. We overestimate how up on current events people are. A lot of people don't even know who the governor of their state is. A lot of people couldn't even tell you, the county that they live in. I've asked my clients, they call me from a new town I'm not familiar with. What county is that? They don't know. So I think there are a lot of people that don't follow the news. But B, that's not the touchstone. As we know from, I don't know if you followed that lengthy hearing earlier in 2024 about impaneling a jury in Idaho in the Koberger case. The issue, this simplifies it. It went on all day with 5 different experts. The issue is not whether people are aware of the case. The interest is whether, despite the knowledge that they have about the case, they can still be unbiased and objective. Now, that's the magic question. We have to go into more detail with more detailed questions of the jury. So I tend to think that, you can probably get an objective juror. I'm not saying it's going to be easy, but we have a lot of attorneys on both sides, and I think they're both going to be peppering these jurors with questions. So I'm not saying it's going to be easy. And Nan, you might disagree with me, but I think they probably can find a panel of jurors who will be honest and who will, be unbiased. I mean, my room is split. When I read my comments after my podcast, there are people that are pro Karen, and there are people that just want to lock her up. So the room is split, and if we can find unbiased people somehow, I think they can do it. I'd be interested to see what you have to say, Nan.
Oh, yeah. And that's interesting because you have your channel and you are seeing, you're producing content, and you're getting both sides commenting and coming back at you and seeing the temperament of where things lie. I think that a jury will be able to be selected, and I have no doubt that both sides will do their best to fully flesh out through the voir dire process the particular trigger issues that might disqualify someone from serving as a juror. And I think with the Koberger case, which if you ever want to chat about that, Andrew, I'm happy to, because I have very interesting feelings about how that case got its way out of the original, I guess it was Latah County, and then moved over to I forget the name of the new county.
Ada County.
And I feel like be careful what you ask for when you file a motion to change venue. But in this case, the only thing that concerns me about juries for Karen Reed is I think there needs to be strong concern about stealth jurors. That's a big thing from my experience here in New Jersey and New York as a trial attorney on the bigger ticket cases. I won't say high profile, but ones where people have a significant interest in them. A lot of people will fake through their answers, or, I won't say perjure themselves through the process of the jury application and voir dire, but enough people hide personal sentiments and have agendas. And I've actually experienced it firsthand, where once a juror was selected and it became very clear that we had to bounce that juror thereafter because they came in with a personal agenda. So people think jury selection for any type of case can be so easy. In fact, on his show yesterday, Aidan Carney said something like, I know a lot of people want to go to the trial on April 1st. It's jury selection. Boring. Don't make that be your big debut if you want to go visit and take a look-see. And I couldn't agree more. So we'll see.
Well, you don't get to, the audience doesn't really get to see what goes on, but I've always found it a fascinating, if not nerve-wracking experience. I'm ready to just bounce off the ceiling during jury selection because it's really difficult. Yeah. But it's at the same time, it's really fascinating if you work with some of these jury consultants because they look at, and I'm not saying a big fan of body mechanics, but they look at everything. They look at people's eyes, their ears, their body mechanics, their hands, whether they're sitting back or slouching, and they kind of read between the lines of how the jurors are answering the questions. I'm not saying that you're not 100% right with respect to shadow jurors. I mean, look what happened in the Alex Murdaugh case. Within a couple of days after the guilty verdict, 3 of the jurors were on Good Morning America.
Oh, yeah.
I mean,
it's like they leave the courthouse and there's already a PR person from some of mainstream media shipping these people off for their appearances. And I find juries nowadays in the wake of the what do I want to call it? Just the introduction of social media. Now that social media, and there are people who are, armchair detectives and sleuths and really following true crime like I am. By the way, Andrew, I'm very much an armchair detective with legal experience. And now that people have such an interest and the information is so widely available, if you choose to look for it, because I agree with you, there are a number of people who don't know about this Reed case from my own experience with my clients up in Massachusetts as well. I feel like there's a strong likelihood that people who go to sit as jurors or go through the application and selection screening process, they can come in with a lot of baggage that may adversely impact their ability to be impartial. So picking juries now in 2025 it's a big challenge for lawyers, especially lawyers who don't have a robust knowledge of social media and all of the tentacles of it. So it's pretty exciting. I will not be there for April 1st because jury selection is a snoozer.
Yeah. What do you think of the one of Britt's commenters? I don't know if you can go back, but one of your commenters up top there said, after modern jury selection procedures, they will whittle down the jurors to morons.
Oh, yes. I know. Yep. Here, I'll pull it up.
I need that.
That was Scott. We love Scott here.
Yes. I see Scott. I need to know more about Scott. Scott's always in all of the streams. So he's either like a mod or a popular chat chat participant and follower. Because every time I go somewhere to chat, he's there. So
Scott McGinnis faithfully serves almost every YouTuber in the Free Karen Reed movement. He's a local. He's boots on the ground up there, but yeah, I can't believe the time he puts in.
I hope he's wrong. I hope he's wrong because I've been privileged to know some really brilliant people in my life, and I could probably count them on one hand the number of really brilliant people I've found in my life, and I'd like to think we could get those people. I'd like to think Scott might well be right, but I'd like to think he's wrong because the really brilliant people that I've known in my life were all contrarians.
Yes.
No matter what you would say to them, they would say, well, but then on the other hand, there's that. So I would like to think that we could get that kind of person that's really brilliant on the jury, that's really going to listen to every little piece of evidence. Isn't that what we want? We want people that will listen to every single piece of evidence and kind of fit it together like a puzzle.
Andrew, I totally agree with you with maybe one exception. And maybe you're not saying this. I definitely think overeducated, which you're not saying. I want to make sure I'm understanding what you're saying. I think a highly educated individual might not be the right fit for a juror on this case, just because of some of the reporting that came out from some
about the foreman and
like there seems to have been some allegedly some jurors or a juror who seemed to take it upon himself or herself to bring their educational background and experience, which, we all should do as well, but tried to kind of solve this mystery themselves. And apparently, from what I gather, it didn't correlate to what the defense or the prosecution might have been exactly saying. So, but I do think contrarians by nature would be a good fit for jurors because, as Mark Betterow says, you want to have jurors who are inherently skeptical of the police or willing to go that far to say, I can be skeptical of police. And that doesn't necessarily even mean I, as a potential juror, would think there was this third-party conspiracy, a third-party culprit, but to be suspicious by nature, contrarian to look what's in front of you. Is this what you think happened, or are there too many coincidences? And if that's the case, that would be a good juror for me. If someone's just willing to keep that open mind and kind of check all the boxes, and they're not a shadow juror or a stealth juror, they're going to seat people in the box, and hopefully that process will be smooth, and hopefully the trial will not take half as long as it did last time.
Well, remember when they tried the case the first time, they didn't have 5 trial days every week. There was one week they only had 1 trial day. There were other weeks where they only had 2 or 3 trial days. So that's why it started on April 15th and it stretched out to July 1st. I mean, but if they hold 5 days a week or even 4 days a week, they can pare that down to, I don't know, 6 weeks, 8 weeks, right in that time frame. So the problem I had with that was that towards the end of the trial, I didn't remember all the stuff that happened in the beginning of the trial. I really and truly didn't. I had to go back and listen to all of this stuff again. And so I don't see how a jury can be expected to remember it all. That's kind of a side issue, I know, but I agree with you that, that's our goal, but how do you find those perfect jurors? How do you find it? The process is not perfect. It's just not.
Well, Britt was singing in the beginning of her podcast one of the tunes from the Willy Wonka movie.
Wonka. Yep.
And,
I'm working on a video for that.
In a world of imagination, maybe jurors like this exist. I will say, as an outsider to Massachusetts, and I'm also happy to say I've put in my application to become a member of the Massachusetts Bar, by the way.
Oh, congratulations. I'll sign off for you.
Thank you. Thank you. What my associate is already a member. I'm not making him sign off for me, but that's wonderful. You've known me for a total of an hour, almost an hour.
Right.
And I might be a serial killer. If you talk to my kids, they'll tell you mommy loves murder.
I retract everything I just said. Forget.
But with all of that said, I will tell you that as an outsider to the jurisdiction, I was a little puzzled by the fits and starts of the trial pace and rhythm. A lot of musical references here, Britt. But and maybe I don't know what was the issue was. There could be just Judge Canoni has other scheduling commitments. There could have been a need for accommodations for the judge, her staff, or jurors. There's a whole slew of reasons why it wasn't just Monday through Friday, 9 to 5 or 8:30 to 4:30, however it works up there. But that case could have been downsized.
That depends on the
Yes.
judge. That depends on the court. That depends on the county. I mean, those things vary. Don't hang the entire state of Massachusetts by what you see in this trial.
Right.
That type of thing all varies from judge to judge. If you talk to attorneys about a motion you're preparing or a trial you're having, the first question the other attorney is going to say to you is, "Who's the judge?"
Yeah.
And that's what you want. You want another attorney to tell you, "Oh, I saw Judge X in chambers and we tried a case in front of him. And oh, how does he do this? How does he do voir dire? So
Yeah.
Massachusetts is it changes, it varies. And so I would look for the second trial to be a lot more smooth. I would look for it to go 4 or 5 days a week. I would look for, one of the problems isn't always the court. A lot of the times witnesses aren't all lined up, or you have a witness. I'm sure you've had this experience where you thought a witness was going to go 3 hours and they just go right in a half hour. And the converse can be true. You think a witness is going to be a half hour, and then by the time you get into it and they don't answer the questions the way you thought that one goes 3 hours. So it just varies. And I would expect that the second trial, if there's going to be a second trial, which I think there will be, I would expect it'll be a lot more smooth.
Yeah,
Who knows?
I agree. So, Britt,
Since we're on, go ahead, Van. Sorry.
Go for it, Britt. I could talk to you all day.
I was going to ask, since we're on the subject of the jury, how do you feel, each of you, that a jury would view our new legal additions, Hank Brennan and Robert Alessi? They each have put forward a very different persona and a very different style. How do you think, from what you've seen from Brennan and Alessi so far, that a jury would view each of them?
Go for it, Andrew.
Oh, gee, thanks a lot. Well, they're both experienced attorneys. Mr. Brennan is a friend of a friend. I don't know him well, but I've sat in the room with him and chatted, as many, many, many attorneys in Massachusetts can say. And all of us who have had any dealings with the man will tell you that he's very sharp. He's very organized. He knows his case, despite what people say. And I know I get nasty comments every time I say this on my channel, and I'll probably get some right now. But I think he made some comments in the beginning that made people maybe underestimate him. So how will a jury go for that? It's really hard to say. Alessi, in my opinion, is just incredibly organized. He's very sharp. Same thing. I don't know the man. He's from New York. I've never met him. I've never had any dealings with him. But just seeing the way that he argues, how could a jury not like that organized kind of a style? I would say that, he's very good at making logical, rational, legal arguments, as is Mr. Brennan. But it's a whole different game arguing to a jury. You've got to really, identify with the jurors. You got to look into their eyes. You got to hopefully make them smile and laugh a little bit. So I don't know. I think, go ahead.
Did you have an opinion on that courtroom, like the application for that the defense made at trial 1.0, where they wanted the ability for the jury to see the witnesses' faces when they were testifying? Because this kind of correlates to what we're talking about.
Well, yeah. I mean, I've actually been in that courtroom, and I've tried one case in that courtroom a long, long, long time ago. It was a tort case. But I can see their point, because in the other courtroom, which is much bigger and more accommodating, in the other courtroom, some of the jurors actually do sit behind the witness box, and you don't know that. Yeah. I mean, you don't want that. You don't want that. You want your jurors to be able to see somebody's eyes and their demeanor when they're speaking. So yeah. I think it was the right call to have it in the other courtroom, but that is a tiny, tiny court. If you came to Massachusetts and went to Dedham and saw that courtroom, you'd say, I don't believe this.
I am coming, by the way.
Okay.
For some of, at least one of the days, pop my head in and then go stand with boots on the ground. But I always look at it on the on television and say, wow, it probably is smaller than it even looks on TV, which is small, you know.
Tiny.
So
It's
I look at
tiny.
that and go, wow. But I do believe in that the importance of looking at the witnesses, assessing them, etc. But going back to that question, which I think is related, I think that a jury will always respond well to good, professional, sound lawyers. And Jackson and Yannetti from trial 1.0 absolutely were. They still are. Alessi is magical as far as I'm concerned. He's musical, whether I'm being euphemistic or metaphorical or not. He is very musical in how he builds, like building blocks, to a crescendo with questioning, and it's almost deceiving. Like I'm kind of listening to some of his arguments going, where's he going with this? Right, there's the baton wand. So I think that on the scientific and technological pieces, he probably, I think, will be tasked to conduct those direct or cross examinations, and will do masterfully. Brennan, I actually, I'm going to be a little bit reserved because I don't like to just criticize lawyers, or to say someone's unprofessional or not, publicly at least. But I will say I believe that he has some of the arguments that I have seen him put in writing and argue before the court leave me to be concerned, because I feel that they are not are not sound arguments based on factual bases that concern me. Those are my opinions. But in terms of his demeanor, I don't find him to be particularly interesting to watch. Now, maybe he's masterful, just like Alessi would be. I find him to be very dry. And juries, they want, I mean, it's the McDonaldization of trials now. Now that trials are so readily accessible via social media, on TV, you know, you can have it spoon-fed to you in reels and feeds and shorts on your phone. And look at that, everyone wants the sound bites and the gotcha moments, and they don't gravitate, from my observation, into these kind of soft-spoken. And I will say, I find him to be a little abrasive with some witnesses and attorneys. So I don't think he's going to correlate well. And a jury, you know, he better invent, if he's already producing new evidence at this point, I think he better invent a snazzier way to grab a jury's attention and to make sure that he's not offending witnesses when he questions them, as, in my opinion, he did of Dr. Marie Russell.
2 points about that. 2 points about that. One is that I think most of us have a different way of approaching an argument to the bench.
Yeah.
And another way of approaching a jury. That's point one. So point two is just a really quick war story. I tried a case. The ink was still wet on my law degree, and I had no business trying a dental malpractice case. But when you're on the bottom of the totem pole, you're told to try the losers. And so I went into a superior court in Massachusetts and had no business trying a dental malpractice case. And I was nervous as hell. Like I said, the ink was still wet on my law degree. And the attorney for the dentist, the insurance company attorney, was smooth and confident. And that's all he did was malpractice. And he went in front of the jury and they smiled and they laughed and they loved this guy. And every time I got up, I was, reading my questions, and I won the case.
Good for you.
I won the case. So I hope that the jury, and I'd like to think that the jury does what we all do at the end of a trial and say to the jury, ladies and gentlemen of the jury, I'd like you to pay attention to the facts of the case. You've been very attentive. Thank you very much. If I've done anything or I have any mannerisms that you don't like or that you disagree with, please forget about me. Just think only of my client man over here. And I'd like to think that that's true, whether an attorney, has a good demeanor or a bad demeanor. I'd like to think it's the facts of the case. I might be naive as hell. I've been told I'm naive as hell, but I won that trial where the other guy on the other side was smooth as hell, and I was out of law school and nervous as hell. So
I think I agree. I do agree with you. And I think you and I both want to believe that. We do want to genuinely believe that, because why are we doing what we're doing? If part of what we're doing is going into courts and making arguments and trying to convince juries of our sound factual and legal bases, then we have to keep believing that. Otherwise, people give up. But I 100% agree with you, Andrew, on that.
who knows? Who knows? The man is abrasive.
Right. Now, to piggyback off of that, there's no question that he's a strong attorney, Hank Brennan. He's got a great history, a great background, a hell of a resume. But, do you guys think that, as any case, especially one like this, one as weak as this for the prosecution, can have any lawyer in over their head? I mean, just unbelievable. When you don't have good facts that can nail the suspect to the wall, it doesn't matter how good of an attorney you are. Do you think that Hank Brennan is regretting taking on this case?
No.
No,
Not at all.
I do think I get the sense he didn't fully acclimate himself to the gravity of the case and the evidentiary issues. Inverted video as an example, before he decided to sign on. I also think he was probably not familiar with the testimony from the trial and the evidentiary rulings and the societal uproar and division of the trial to 1.0. But no, I don't think he regrets it now. I think it's probably a personal mission for him. Although I have said, I do believe that he is pot committed at this point.
Yeah.
In other words, while it is 100% true, a prosecutor and or a specially appointed district attorney, whether you're working in the office or you were an outside vendor, they have exclusive authority to voluntarily dismiss charges at any time. They can even do it during trial. They can even do it when a jury is deliberating in my jurisdictions. But I don't think he would do that, because he strikes me as someone who likes a good challenge. And we can all agree, whether we all fall on one side or the other of the conflict over this case and what happened, we can all agree that there is a disparity of opinions on what really happened, and no one is going to ever know exactly what happened.
100%.
Unless there is like a drastic change of circumstances and somebody, if you believe in the third party culprit defense, if someone was going to confess or turn state's evidence, or the federal investigation, which I believe is ongoing still, discovers and unfolds some new facts. That federal investigation concerns me, though. Go ahead, Andrew.
I have to disagree with some of your commenters. He was a prosecutor. He started out of Suffolk University Law School in Boston. He started out working for a district attorney.
Okay.
He's worked with district attorneys. He's worked with that district attorney's office in Norfolk County. He's worked in other counties. And so, yes, he is, in fact, a prosecutor. He started out as a prosecutor. And I like the law that Sherry D has told us. I like the law that she told us, but law is one thing. And if you're hired to be a prosecutor, you want to win your case.
Yeah.
Of course you want to win your case. You have to, the ethical requirement for all of us, no matter whether you're a prosecutor or a defense attorney or you represent, tort victims.
Yeah.
Your duty is to zealously represent your client. And so if the law that Sherry just put us on the bottom of the screen
I'll bring it
is
back
the
up.
law. But the reality is that we do all have an ethical duty to zealously represent our client, even if the client is Norfolk County or the Commonwealth of Massachusetts. So,
man, Andrew, I was liking you up until this last exchange. Now, no, I still like you, but But I disagree. While we do have an ethical obligation to zealously represent our clients, there are constitutional provisions in both Massachusetts and United States Constitution and rules of ethics, whether they're called professional rules of conduct in your state, that specifically limit and guide and contract what a prosecutor or a specially appointed district attorney, whatever the terminology is for Brennan, which I have no doubt. I had no doubt that he had prosecutorial background, but at this point he's an outsider, which I'll hold aside. And I know that you were kind of querying Betterow on that previously in terms of why did they go outside of the office to hire him, which will be the mystery to sail 1,000 ships. But once they did, Brennan has the same. I mean, he is, as he said in court on Thursday, I am the Commonwealth at this point.
Yeah,
and
that was not.
The ability and duty to dismiss charges, even as an outsider, or to walk out of a courtroom like Erlinda, whatever her name was, out at the Alec Baldwin trial. Please forgive me.
Morrissey. Right?
Well,
Carrie Morrissey, yeah.
Carrie Morrissey, and then the other
Erlinda
last name's escaping me.
I think her name was Erlinda Johnson, who worked with Carrie Morrissey, the afflicted, specially appointed prosecutor on the Alec Baldwin trial. But once it became readily available and apparent through the hearing, this little kind of plenary hearing that Judge Summers was holding on the Alec Baldwin trial, once it became readily apparent that things were not all normal in Denmark, so to speak, Linda Johnson, I think is her name. She was also a special prosecutor. She walked out. She walked out and said, I'm done here, because Carrie Morrissey was pot committed, dug her heels in, put herself on the stand, which no lawyer would ever tell her to do. So I don't want to digress off Karen Reed, but I do believe till my dying day that Brennan and or Lally can just walk off this case if they felt that, even if they think, man, she did it. But in looking at some of these missteps and late produced evidence and the shenanigans of inverted videos, late produced videos that are showing Brian Higgins on the phone in the middle of the night at the PD, the backing into the Sally Port.
All that new stuff is crazy. That's crazy that just came out.
It's
just
nuts. Andrew.
Yeah.
We're going to have some fun. Like, I can't wait till you produce a show on once that motion to dismiss comes out, because I'm sure it will be referenced and or during the trial. I'm going to continue to follow you assiduously.
Oh, we'll follow this case. We'll be right on top of it. I think maybe you misunderstood what I said before. I agree absolutely that if they know for certain that someone is guilty, if they know for certain that someone is innocent, it's unethical for them to prosecute that. But you yourself said that none of us will ever know what happened that night. And all I know is that the people, and I don't want to argue against myself, but the people inside of that DA's office and at the Attorney General's office and this was a quote that was told to me, they're mad as a wet hen. They're mad as a hornet's nest that they lost the first case. So they're not going to back down. So please don't misunderstand me. I respect the law fully that was quoted on the screen there, but they certainly strongly believe in their case. They're not going to step away. Anybody that thinks they're going to drop this case and step away really needs to analyze it a little bit more, because as you yourself said, Nan, we don't know what happened that night. We don't. None of us know. On this side, maybe the people on the inside do, but we don't know that. And if Brennan wants to prosecute the case, he's going to prosecute the case. I mean, I'm not siding with him at all. I'm not, and I'm sorry if you misunderstood what I said, but nobody's going to drop this case.
Andrew, I agree with you, but I got to ask you a question.
Sure.
I'm from New York, New Jersey, so.
Well, I'm from Pennsylvania.
Oh, good. I can be a little.
So I don't know I don't know what it means that you're from New Jersey. I spent a lot of time in New Jersey growing up. I had family there. We went to the beach there. So I don't know what that means that you're from New Jersey, but go ahead.
I can be very direct.
So can I.
Do you think that the prosecutors, be it Lally, Morrissey, or Brennan are aware that there are evidentiary shenanigans, gaps, holes, malpresented evidence in this case? Do you feel that way? Do you
You have
think
to ask them. I'm not going to defend any of them, especially Carrie Morrissey.
But
I thought that she was repugnant. The first time I heard her open my mouth, I thought she was repugnant. But that's not my case. That's not what we're talking about today. So no, I'm not going to answer that question because I'm not them.
Yeah,
Well-
I guess what I'm saying is, at least from my book and my perspective, it is very evident that a prosecutor knew or should have known that there is exculpatory, inculpatory, or impeachment-based evidence that was very readily apparent and was not produced previously in 1.0 and now for trial 2.0. I'm not even convinced they've produced everything. And in the wake of that, it is my position that the prosecution should not go forward. There should have been a mistrial, not how it ended in 1.0, but like inverted
with prejudice.
video.
Yeah.
Inverted
If you're asking me to argue their case, I'm not going to do it because I tend to agree with everything you said. I tend to agree. I thought during the whole first trial, people were saying Lally this, Lally that, Lally this, and I'm saying to myself, as a member of the Massachusetts bar, I'm not going to disparage another member of the Massachusetts bar, and I think we've all been, our heads are shaking that nobody else in the district attorney's office wanted to try this case, but he looks like a nice guy. He looks like the kind of guy you wouldn't mind going out and having a cup of coffee with. But as a trial attorney,
Mm-hmm.
and
that's as far as I'm going to go. So ask them those questions. I'm not going to stand up for them. I think that it was a tough case for them to try, and you need to have one of them. I've actually, by the way, and I think I'm the only podcaster, I think I'm the only reporter that's actually asked Morrissey's office to come on my podcast or provide somebody to talk. For example, as one example, back when Vanity Fair came out and they said that Vanity Fair reported that none of the top trial attorneys in the Norfolk County District Attorney's Office would try the case. They all refused to try. I said, that can't be true. That's crazy. I actually talked to a reporter that I know in Boston, and I said, can you believe that? He says, Andy, we're working on that. We're going to try and get a statement on that. Then I called Morrissey's office that day. It was October 30th or 31st. I called his office. I actually got a human being in the press office, and he said, I can't really talk about that. I can't give you a comment. And he went back. He said, look at this press release we did back in September. And I said, yeah, fine. And the press release had nothing to do with that. And so I said, could you call me back and give me an answer to that question? Is that Vanity Fair article allegation true? He said, okay. So then that day I faxed them a letter to their fax number that's on their website. So they've had every opportunity. I said, look, you just hired a new press person that month in October of 2024. They had hired a press person, a new press person who used to be a reporter at a well-known newspaper in that area. And I said, I understand that you can't come on, but have somebody come on my podcast or just write us a letter, write us a fact and deny that. So I'm the only person. You have to ask your pointed questions to them. I've asked them, I've called them, I've faxed them several times. I've invited them to come on to my podcast or just give us a statement. And so those questions have to be asked to them because I don't think they have the answers. And I don't think they have the, how shall I put this? I don't think they have the whatever it takes to actually answer those questions.
The chutzpah.
Thank you.
My mother was Jewish. I don't know if that's a Yiddish word or Hebrew or any of that, but
it's Yiddish.
She often would say that word, so it's ingrained in me. Britt, before you ask your next question, I respect Andrew's opinion on this, but I want it very clear. From my perspective, these prosecutors know. Morrissey knew with his hostage video.
Yes.
I can't speak to how that was perceived back in 2023, I believe. They knew he should never have put that video out. I'll hold any opinions on professionalism or lack thereof by doing it. Lally knows. and Brennan now knows at least directly, or he has imputed knowledge.
Mr. Glarer has
Yeah,
said,
Will's
and he's
here.
invited me to be on his show. We've just never gotten the time. I think the word you're actually looking for is integrity.
Yeah.
Yes, 100%.
Yeah.
So Nikki says, let's say they uncover evidence that the taillight was planted. Would they continue with the charges? This really speaks to what I don't know at this point.
Oh, you cut out for a moment there, Britt.
Andrew, I just don't know.
Would you like to go ahead?
Why do you keep asking me questions as though I'm the prosecutor?
Oh no, I don't.
That's not my rule. That's not my role here. I'm not the prosecutor.
No, I didn't want to interrupt you by jumping in. I'm an alpha lady, so I'll just being deferential. I mean, I'm happy to answer it, but Britt, you got to put it back up.
Oh, sure. So what do you think Bev would dismiss the charges? Nikki says, let's say they uncover evidence that the taillight was planted. Would they continue with the charges? What do you think, Nan?
The case law, both at a federal and from what I observed on the state of Massachusetts level, which has been very superficial. Let me be very clear. My Massachusetts state law review, very superficial, but the laws, the written precedent would say, yes, she has to dismiss it with that, because that is clear evidence. That is Brady evidence, and it probably falls under a number of Brady progeny, which I won't bore your audience about that. But in addition to that, besides the whole third party it has to have been a third party if it was planted, right?
Right.
Holding all of that aside, I have no confidence that Judge Cannoni would dismiss it. She would say this is a question for the jury, whether or not it was uncovered and whether it was or indeed planted. So I guess Nikki's question is a little vague to me, because I'd need to know how it was uncovered and whether it's simply a version of, someone's maintaining an allegation that it was uncovered. Ultimately, I can't predict what Judge Cannoni will do. I would dismiss it if I were a judge, and given her past performance in pretrial and trial 1.0, I don't think she would.
I think there's pretty strong evidence that something funny happened with that taillight. I mean, come on, they were looking for evidence with a leaf blower, and they were picking up blood evidence with solo cups. So I think there's already really strong inferences that at the very least, and I'm saying this is a hypothetical question, but at the very least, there's no chain of custody on any of that. The evidence was not collected in a professional manner. Even a 6-year-old who watches true crime can tell you that the way that crime scene was investigated was highly not by the book. We'll put it that way. So that's a hypothetical question, but would the judge dismiss it? No, she'd find a way to not dismiss it.
Hey, Andrew.
Yeah.
Question for you. Do you feel that it might help Karen Reed's side if she were to produce an expert in police procedures, police policies and procedures, in trying to show that there were missteps here? And by way of example, like in the OJ case and many others, but in OJ's case many moons ago, they were really staying more away from he couldn't have done it, he didn't do it. It became a racial case predominantly, but there was a heavy focus on police misconduct or ineptitude. Do you have any opinion about that?
Yeah, I do. I think that'd be, I've thought of that myself. And I know that there's another podcaster out there who's had an expert. There's another podcaster on there who is a retired detective in Los Angeles who has commented on that. And he's a really bright guy. So my answer to your question is yes. But remember, in the Alexander Murdoch case, I don't know how closely you followed that, but the night that Maggie and Paul were found, he called all of his business partners, and his partners and friends were all walking all over the crime scene. And it's just, even though, despite the total unprofessional conduct of the South Carolina, law enforcement, they got their conviction. So I think the answer to the question is they should have an expert, but whether that helps or not, I don't know. I don't know the answer to that question.
Yeah, and let's hope Alec Murdaugh doesn't get retried. I think he may get a new trial. That's where it's trending in my mind. But
Yeah.
that was a dumpster fire.
That was a dumpster fire.
And also an affront to the attorneys who do try to practice with integrity, which you and I are both. I'm going to include us both in that bucket.
Thank you.
Know? Anyway, Britt, what do you got?
Well, okay. Do you how do you guys feel about the aggressiveness of the approach that the defense took from the very beginning? They brought in this, third party culprit theory, which, they do have a lot of strong evidence that points toward that. But is that how you guys would handle it had you been defending Karen Read? Would you have gone with that approach, or would you have just stuck with reasonable doubt and poking holes in the Commonwealth theory?
Oh, I'm not going to second guess a team like David Yannetti, who, by the way, graduated from law school the same year that I did and sat for the bar at the same time in the same place that I did. I mean, I've never met the man, but we've been practicing exactly the same amount of time. He went to Boston College. I went to Suffolk. I'm not going to second guess him in Alan Jackson, because legal strategy is something that we all do, and we all have different approaches. And I'm certainly not going to second guess Attorney Alisi, who's a top shelf attorney, as one individual attorney who does mostly, I've done defense, but I've done mostly civil stuff my entire life. Yeah, I would have focused more on reasonable doubt, because that's really the, I don't want to say the game, but that's our strategy. That's our strategy. A lot of people misinterpret, well, you have to prove what happened. No, all we have to do is prove reasonable doubt. So the answer to the question is, I would never second guess this top shelf criminal defense team ever. But I think we might see a change in strategy in the second trial. That's how I can answer that question.
Yeah. And
What do you think, man?
It's interesting, Andrew, because I know that you had interviewed Mark Betterow, and at some point during that conversation, which I thought was really, really interesting as a lawyer to watch that, to see the two of you bring such insightful pieces, and Lainey too. And, he was saying, or you were saying, and I don't remember which one, that, you can't change the facts. The facts are what the facts are. I mean, it's alarming and concerning, I think, for both of us, that there seems to be new facts. For example, to your audience, Britt, like, okay, Higgins. Sorry, I don't want to refer to him as Higgy. In other circles, I do.
Higgy, can't you see?
Yeah. Higgins was apparently on the phone and maintained by some to possibly have been ordering food and beverage at 1 or 2 o'clock in the morning. But I digress. That's an example of like a new fact. But the facts are the facts, as you and Betterow were discussing. And considering that, I feel like it's okay to change strategy. It is also okay to change experts. Like, it does appear, I could be wrong, it appears that the prosecution will possibly or likely not be going with Trooper Joseph Paul moving forward. Congratulations, Commonwealth of Massachusetts. In my opinion, you've made a smart decision finally on that. Because my 9-year-old son could have been a more effective accident reconstructionist than Trooper Joseph Paul.
Oh, anyone could have.
Yeah. Maybe even Ray Charles, Amelia Earhart, you name it. They could have been more effective, even if they didn't see it or hear it, that crime scene. And it was a crime scene. So I feel really passionately about that. This wasn't just the scene of an accident. You had officer down, very little responding officer interest or just officer response at all. And I just know that that's just not how it works. I've got officers in my family, in my personal life, etc. It's okay to change strategy. It's okay to even enhance with experts or modify experts. Can't change those facts. You're kind of married to your facts. And sometimes, and I think Andrew would agree, when you don't have the facts on your side, you argue the law. When you don't have the law on your side, you argue those facts.
You're banging the table.
Yeah. Or like, look the other way type of thing, which has been alleged in this case as far as observation. But with all of that said, I think that ultimately focusing more, because I don't feel that and I only have a little critique for Karen's defense team. I don't feel like they stressed on a very spoon-fed level reasonable doubt what it really means. Like, I think that they thought by calling as few witnesses as they did, but they did get a lot of evidence through cross-examination. But as few witnesses as they did, I think they really did believe that reasonable doubt was abounding. Spoon feed it to that jury and emphasize the sheer number of coincidences. That's going to make all the difference, in my opinion. I'd be very disappointed if they take that approach and this does not end favorably for Karen. But I refuse to believe that that will happen.
Yeah, just one real quick note on Joseph Paul. As a personal injury attorney who's done accident cases in the city, accident cases in rural areas, accident cases on the Massachusetts Turnpike, I have seen really detailed accident reconstruction, accident reports out of the Massachusetts State Police. And they're very detailed. I'm thinking of one that happened near Worcester on the Mass Pike. And this thing went on for 14 pages plus additional exhibits. And just the detail that they went into to show how that accident occurred, it just shocked me that I hate to disparage Joseph Paul, but the level of insight into what happened in whatever happened that night between John O'Keefe and Karen Reed was kind of down here. It was kind of like a D minus, where some of the accident reports I've seen are like an A plus plus plus, even with concepts of physics and speed and time and everything else. So having seen really detailed Massachusetts State Police reports, I was just really, that's it. Is that all there? Who was the singer that said, "Is that all there is?" Really?
Yeah.
So I was shocked that that's all they had.
Me too. And without the local perspective you have, like, could have done a little better. But I'm interested. I find that very interesting that from observation and personal experience and being boots on the ground, that there could have been maybe a better outlay of.
No question.
Yeah, and
No
also
question.
one thing I will tell both of you and your audience that keeps me up at night a little bit after I listen to content creators. I'm still not 100% certain from a strategic standpoint if the prosecution can change its opinion on how John O'Keefe was struck by the vehicle, because they did take a position that he was sideswiped by Karen's car in 1.0. And yes, that evidence came through Trooper Paul's testimony. If Trooper Paul is no longer in the equation, maybe, that has not been confirmed, but by looking at the certificate of compliance and or the what was produced, the list of it appears they have a new accident reconstructionist. That accident reconstructionist may supplement Trooper Paul or may completely replace Trooper Paul. I don't know if in Massachusetts they're now permitted to change how it all happened and say, "Oh no, she knocked him," and there's an anti-free Karen reader out there who has I think I had heard a new video with a new way of John O'Keefe sustaining these contusions to the back of his head, etc. So
yeah, I don't even think that could happen in Looney Tunes. What he posted,
at the risk of, I don't think it has anything to do with Massachusetts. It's just basic evidentiary law. At the risk of being cross-examined to hell and being impeached. I mean, if they have a different theory this time, why can't whoever has the chutzpah, we'll say, to go on the stand with this new theory, why can't they be cross-examined? Oh, well, you say this. Well, here's Joseph Paul's testimony, and isn't it true that he said this?
But Paul, well, I respectfully partially agree and partially disagree, because if Trooper Paul has been assigned to an oil tower in the Antarctic and is going to not be seen from and isn't going to testify in this case, then it is my at least basic understanding that his report isn't going to be evidence in this new trial.
Yeah. What about his sworn testimony?
Well, his
What about his sworn testimony at the trial?
Well, I will tell you that here's my theory on that. This is why this keeps me up, because his sworn testimony is Trooper Paul's sworn testimony. So if he's not going to be called as a witness, then his sworn testimony doesn't come into court to impeach new witnesses, like the new accident reconstructionist. It's hearsay at that point. It's out of court. It's a prior court proceeding, in my opinion, prior court proceeding. And the best evidence would be to ask those questions directly to Trooper Paul. Those statements of Trooper Paul, and I don't want to like put your audience to sleep, Britt, with like evidentiary, anathemas, but Trooper Paul, if he's not going to testify, his report doesn't come in, his prior testimony, in my opinion, is not the new accident reconstructionists. So at best, what I would do if I were Alan Jackson or Alessi or Yannetti cross-examining new accident reconstructionists, I don't think I can say, did you know that the old accident reconstructionist, I'm trying to keep this G-rated on Super Bowl Sunday, but
we don't care about that here.
Are you aware that he had these opinions? You can't do that. It's here.
Yes, you can. I respectfully but totally disagree with you. If the new guy is brought in as an expert and Joseph Paul was an expert, loosely speaking, yes, an expert can always be cross-examined and asked about other material of the type that other experts rely upon. So if Trooper Paul said X in trial A and a new guy comes in and says Y in trial B, the new guy can say, oh, really? You're an expert? Yeah. And you have this education, training, and experience? Yes. And what kind of information do you rely upon in your analysis and arriving at opinion? Well, I read this and I read that and I read, and you've read reports of other officers, haven't you? Yes. So Paul's testimony, I respectfully disagree with you, absolutely positively comes in for at least cross-examination and very likely opinion. Oh, absolutely.
You're gonna make me do more research and look at that. We have a Super Bowl of lawyers.
You can't change your whole theory of the case and expect the jury to buy it. No, if I were an expert, I wouldn't want to come in and totally disagree with what their story was the first time. Absolutely not.
Yeah, but I'll drop it at this point. But this new jury doesn't get to see the old version. They get to
absolutely they do. Yes. Absolutely.
And I disagree. And this judge will also play tremendous gatekeeper and has been quoted as on the record herself. This is a different trial. This is a new trial, but we'll see what happens. I think with this judge, she's going to keep any reference to Paul out if he's not called as a witness.
Well, if he's an expert and he testifies, he has to acknowledge that he relies on reports and examinations and legal tomes and briefs and state police opinions. That's the kind of thing that an expert relies upon in arriving at their opinions generally. Yeah. So in this case, didn't you read what the Massachusetts State Police said about this? Well, if he says no, he's an idiot. If he says yeah, it comes in. Absolutely. No question.
This type of issue was discussed on one of the mainstream media programs 2 days ago. And they basically said this was the risk that the Commonwealth was willing to take. They're willing to forego Trooper Paul and kind of, as I feel they're doing with Lally, make him a scapegoat. I think if I were to predict what will happen is the new accident reconstructionist, even if evidentiary rulings let him review, reference and be confronted with Trooper Paul's prior testimony, which I think we can disagree as to whether it's going to be admissible. But with that said, I think the new accident reconstructionist is probably going to say, yes, I reviewed it, if it's admissible. I reviewed it and I thought that I can even further enhance it. And he's going to, he or she is going to, do some magical tricks and say, well, it said this, but in looking deeper at it, he was on the right track, but let me enhance it further.
And what's a jury going to think of that? Oh, so this was their story before, and now this is their story this time. What's a jury going to think of that? I'd love to be on the other side of that one.
Me too. Me too. But there were so many times I thought this jury 1.0 should have been like, what's going on? And it seems like from some interviews of the jurors, they were. Then it seems like there were some jurors bounced who really felt that way. But it does look like there definitely was some obfuscation going on as it related to the jury. Like this jury was not permitted to consider ARCA having been engaged by the feds, which I did think of something the other day. Sorry to hijack your story, your show, Britt, but I was thinking.
Oh no, this is what I wanted, y'all. Like this is exactly what I wanted to happen. So I wanted y'all to go at it.
I was thinking about it the other day, maybe like 2 days ago, and I was like, well, I don't think Judge Cannoni is ever going to let into evidence the federal piece other than the light amount she has previously. Like there have been mentionings of prior testimony. Did you testify to this in a prior proceeding? I don't think she's ever going to let it come into evidence that ARCA or the Crash Daddies were engaged by the FBI. But in my opinion, if the judge wasn't going to allow that in for 2.0, in my opinion, it is reasonable for Karen's defense at a minimum to ask, and they may want to do this with a pretrial application, ask the question to the Crash Daddies. You will agree, or am I correct that you were not engaged by an insurance company? Now, there is a general rule that you don't discuss insurance companies in court or settlement, but there needs to be, in my opinion, a pretrial application asking for an exception here. Not to say who they were engaged by, but to dispel any misleading or inference of confusion that might have caused jury 1.0 some confusion. And it was that insurance piece. So, that's just a suggestion unsolicited to Karen's team. Even if you can't say they were engaged by the FBI, there may be ways of kind of talking around that, and it may be best to do so in the form of pretrial applications.
Yeah, there's a pretty strong jury instruction in Massachusetts about you are not to take into consideration insurance. But I know a guy that was on a jury in an accident case, and the jurors didn't want to give the poor person anything. And the jurors, even though they were given that instruction, you're not supposed to consider insurance, the jurors were saying, this person in the jury room while they were deliberating, this person got their medical bills paid by PIP in Massachusetts. Why should we give him anything else? So insurance was, in fact, something that was considered in this actual jury. And I took part in a ATLA conference one time where we actually tried a case in front of mock jurors so we could learn how they deliberate. And in Boston, in this mock, they just pulled jurors in off the street from all parts of Boston. They all talked about insurance in their deliberations in a similar fashion. They got their money, they got their insurance money to pay their medicals. Why should we? These lawyers, they just want more money.
Yeah, I mean, it's interesting. I want to look at those rules up in Massachusetts. It's kind of frightening how, on a granular level, I'm digging my way into your state, piece by piece. But maybe there's an exception to be asked for. And Andrew, you would agree. Sometimes when there's court rules or precedent, we make new precedent by having new cases, new challenges, new appeals. And
with this judge,
I know. I need to drink more coffee or something stronger today to hit myself over the head. But with that, I feel like this issue, the correlation between the FBI and ARCA, is probably exceptional because it's not a civil case. I do, as do you, a lot of civil litigation, including products, by the way. My practice, a lot of the doctors have patents and products, et cetera, that go awry. But with that said, this is a criminal matter. And none of the parties, it's not like none of the parties are aggrieved and receiving insurance benefits that are
Right.
relevant to the trial. It's more of a very isolated point. I can see Alan Jackson arguing it now, or Alessi, or Yannetti. Your Honor, I know you're going to deny me, Your Honor, but let me tell you, this is an issue where you had jury confusion. And this is an issue where the prior jury thought that, while we abided by your order and we weren't going to reference this agency for all of the prejudice that could have caused or undue influence on their opinion, we would like a very limited amount of latitude granted from the court to simply dispel who they were not engaged by. In fact, I might draft that brief and just for myself, because I think it's an argument to be made, and this is the level that I get ingrained in these cases.
So guys, since we only have a little bit of time left, because Nan has places to be today. She's got a basketball game to go to, and it's Super Bowl Sunday. We don't want to keep y'all from that. I want to make sure that we get to some of the questions that were asked here in the Savage Patch before we hang it up and go. So first of all, thank you again, Thomas. He is the very first super chatter on the Brit Happens show. Thank you so much. I know we've already acknowledged you once, but Eric says, how can it be stopped? Morrissey's next act of corruption, many corrupt jurors in Karen's second trial. I mean, I would say that it's just a matter of following the rules and procedures in court. Am I right, guys?
They're there to be followed. Yeah. I mean, how can it be stopped, though? It's a great question, Eric Alameda. As I see it, the best way for this to be stopped is for there to be a complete revamping of how Trial 2.0 progresses with, full-throated, to use Alan Jackson's saying, full-throated objections, objection, hearsay, objection, misconstrues evidence, where the bases for those objections are set forth on the record, where there is, in my opinion, a very balanced application as to objections that are raised, a balanced application as to what evidence does come in and what does not. Plenary hearings, side hearings, and maybe they took place in the form of sidebars, but there needs. You even said sidebars earlier, Andrew. Though, so
I'm not from here. I'm not from here.
Pennsylvania. There you go. But there, even in the form of sidebars, there needs to be full discussion with the court as to the shenanigans that are going on, if they're permitted to go on. Like, I'm using the inverted video as just an example. That is nuclear. That is exceptional. Never should have happened. Trial should have, at a minimum, shut down right there.
Mm-hmm.
So we can only hope. But one of the reasons I've gotten involved a little bit more visibly on this movement is to help change public minds and bring more attention to the case. So there's a groundswell and a force multiplication, and maybe all of you can tell a friend and tell a friend and tell a friend. And this type of shenanigans, as I see, comes to a stop. But I don't think it's ever going to stop unless there's a full acquittal and a reckoning in the form of a extremely robust reform and an absolutely powerful civil rights action and a full-blown investigation that is public to the taxpayers of Massachusetts.
No, I would agree. Strong defense. I agree with everything that you said. It's a very strong, vigorous defense. That's all I can say.
OnlyFan asks, why do you think Brennan is compiling all the interview notes?
Barking up the wrong trees. He's look, I mean, we can all understand, and I think your audience can too, that Karen has a Fifth Amendment right to be silent. She doesn't have to incriminate herself in a criminal proceeding. She also, as I understand it, in the civil action, the wrongful death action filed against her by the O'Keefe family and relatives against Ms. Reed and the local dram shops or bars, that her deposition can be stayed pending her criminal action. So she doesn't have to testify in a civil action before she has her criminal action. That doesn't mean the whole case is stayed unless I missed news. Because someone said to me, no, they said, oh no, the whole civil action is stayed. That was not my understanding.
No.
But with all of that said, she has a Fifth Amendment right to be quiet and not to incriminate herself.
Right.
She's talking to news outlets. If I were her attorney, and I know Betterow agrees, and you may too, Andrew, like I wouldn't have her give interviews because of the gamesmanship and the inquiries Brennan and the prosecution are making.
Right.
But he's hoping for something. And he has, I mean, I get it. He wants to know what was said, even in a private nature in the form of journalism notes. So on the off chance, A, he finds something really incriminating, or B, she goes on the stand. If she goes on the stand during her defense, which is her choice, and if she waives the right, it's going to be a full and knowing waiver on the record that the judge will elicit from her. She goes on the stand, he has the right to cross-examine her on inconsistencies. So I think if the prosecution is barking up trees to show what did you tell reporters, which wasn't confessions, or what did you tell, how many times did you call your parents, and what did you do with this and what did you do with that? If that's the best they can do as a pretty zealous litigator, I'm looking at this going, they don't have anything, nothing, you know. And Brennan can make on the record a statement last Thursday saying it was voluminous, Your Honor, it was voluminous. You know how many, and maybe you'd agree, Andrew, I won't ask you to comment on Brennan just due to the geographic ties there, but you know how many voluminous productions I've gotten from an adversary, and out of all of those 3,000 or so documents, maybe 2 were relevant. Like, I don't care how much paper you have. You know, your paper's bigger than my paper. That's great. I only need 1 or 2 of them. So I'm interested to see what they move forward with.
Nope, I would agree pretty much. I do think it was a mistake for her to go to do those interviews with Boston Magazine and Vanity Fair, even though she looked very good in the Vanity Fair article. I mean, she opened herself up. The reporter moved in with her for 3 days or whatever it was. It was a mistake. It was a big mistake. And I think it's a mistake. I think she's innocent. I think that she should be acquitted. But it's a mistake for her to go on the stand because an aggressive, avid prosecutor, and I think you'll agree with me, as you've been saying all the way through this, I think you'll agree with me that an avid, aggressive prosecutor will take one little misstep and blow it up beyond all recognition. So I think it's a mistake. I think she has a very good defense team. I think they're recalculating. I think they're focusing. I think they're sharpening their attack for the second trial. So I think it would be a big mistake for her to go on the stand. I really do.
I agree.
Sherry, thank you so much for your 5. She says she was watching you, Andrew, on replay and saw that we were live here. So thanks for being here, Sherry.
Thank you. Andrew, we just dropped, I'm sorry, go ahead. We just dropped a new episode this morning on the Idaho 4 case. So yeah.
Oh, I'll have to watch that.
Wonderful.
It was just me rambling. It was just me rambling this time.
Yeah, that one makes me ramble too.
Oh, yeah. Christine, aka K Fan, thank you so much for your 5. She says, great panel and good luck. Thank you so much for being part of this itty bitty baby channel. Miss Jessica said she was tearing up in pride. Thanks, Jessica, and I'm so glad that you're here. Josie Lou, thank you so much for your 20. Wishing you success. Claim intellectual property rights to an unchecked lie becomes the tooth. Just subscribe. Thank you, Josie. If you guys don't know, and here I'll just pull it up for you now. I made a little meme. It wasn't the nicest of memes about Jennifer McCabe, but I simply had to. Here it is. Let's do a screen share. This is what she's referring to. Bear with me. I'm working with a little laptop here. Okay, here we go.
Oh, I saw that.
Sometimes I just can't help myself. So thanks so much, Josie. Appreciate it. I did put my little brand on there. So
It is interesting though when he did say an unchecked lie becomes the truth. It's
Mhm.
very, I guess the word, I'm an English major. I guess that would be ironic. There's probably another literary term of art to describe that, because that phraseology could apply to both sides of this
Absolutely.
dispute.
I think that's
100%.
similar. I think that's similar to the one of the top 10 tools of the propagandists is that if you say it enough times, it becomes the truth.
Yep.
Mhm.
So that if a lie is repeated enough times, it becomes the truth.
By mentioning this, there was I'm gonna look and try to get it to you, Britt. There was a show, like a little documentary on Netflix a few years back about a societal experiment where one little lie was told, and that little lie, it was a blend of the telephone game where
Yeah.
and then it was people then started to believe it and then change their conduct accordingly. And it was all done, it was all fake, meaning the lie. It
Mhm.
was done to kind of trigger societal responses. But I'm thinking about it, it had a tremendous
Impact. Yeah.
relevance here. So I'm
Yeah.
for it.
That's right up my alley. Just shoot me a text with the title of it.
I will.
Just a girl from Fall River. Thank you so much for your deuce. We appreciate it.
She has a Fall River accent.
Yes.
Remember that?
Weird Fall River
Yeah.
accent.
What does that have to do with anything?
Yeah, that alone, even holding aside the more salacious comments he had in those texts, he shouldn't, like, just like you said, Andrew, like that the responding or investigating officers shouldn't be basing any opinions on that, commenting at all on it, letting anything about that color their mindset, even especially because at the time those texts were going through was less than 24 hours.
It's the same day.
Yeah. It's interesting. And
Super Squirrel, thank you for trying to support the channel. Shoot me an email at brithappенschannel@gmail.com. And we'll get with what might be going on there. I just opened up that account. So now, just a girl from Fall River also asked, Hank has an expert meteorologist that's going to testify. Can you explain on what he will be testifying about?
How much snow there was in the driveway. I mean, not that that has anything to do with it, but there's this whole theory about, did the vehicle back up 26 feet or 26 miles an hour, whatever it was? And
Yeah.
the answer to the question is whether the tires were spinning or not. And we've had a running dialogue as to, well, if there was snow or ice on the ground, the tires can spin and the car's not moving at all. So,
Right.
Yeah.
Very true.
The answer is correct there as well. I think also there may be some relevance as it relates to the evolution of the production of taillight pieces. But I put this in the bucket of if you're going to rely heavily on meteorologists and or other kind of irrelevant, in my opinion, science to address this head on, and that's the best you can do, okay. Bring a stronger defense.
Mhm.
Don't rely so heavily on the third party culprit. It's there. It's already there. And
Yes.
I think that would be a better approach for them.
I mean, I don't know, but I mean, if you watch the trial and you watch the video they had of the first responding officers, it was snowing. It was snowing heavily at that time. So you don't need a meteorologist. I mean, you can take judicial notice that it was snowing. So I think what they would be, and I don't know, I think what they would be doing is trying to figure out whether there was snow or ice in that driveway the night before at the moment that the Lexus was said to have backed into O'Keefe. I haven't seen it, so I don't know. That's only my speculation.
Yeah, I think that's good. That's a good point.
Opal asks, do you think the defense will put Lally on the stand?
I don't know if they, you know what? I always tell people when I don't know an answer, I've
Mhm.
never thought of that question. So I'm gonna wing it and then reserve the right, as attorneys reserve the right to
Right.
further comment. But I don't see that Lally could be put on the stand. He's an attorney who represents the Commonwealth in this matter. He is still representing the Commonwealth in this matter. So I do not feel that Lally would ever be on the stand in this trial. If it develops that there may have been some malfeasance, misconduct, gross negligence, gamesmanship, or other in the hiding of evidence, the rollout of evidence, any of that, I think that there will be a time when Lally has questions to answer. You know, what did Ricky used to say on I Love Lucy? Lucy, you got some splaining to do.
Oh, right, right.
Yeah.
I think he will have a time. Lally will be answering questions at some point, just not in this trial, if things develop and progress in the way I think that they will.
Yeah, I would tend to agree, unless there's some specific theory of relevance that he observed something. He's got immunity. You can't put him on the stand, I don't think.
Will, thanks so much for being here. We're super glad to have you. Thank you for your 10.
Hey, Will.
That's
me.
Miss Nantastic. Oh, look, it's you. Thank you. Like, oh my
Good luck to you.
Was
Good
that
luck.
a mistake? Like, did you type that by accident?
All the
Oh,
best
goodness.
to you. All baby channels, all big channels were baby channels at some point. Wishing you all the best.
Well, thank you so much for your generosity and for your generosity to other creators. I mean, you've just been so supportive
Thank
to
you.
everybody. Mary Jo asks, can the Commonwealth change their theory? I think we kind of touched on this already about, referring back to Trooper Paul, even with a new with a new accident reconstructionist. So Mary, I would recommend that you kind of wind back and watch that. We've got a little bit of a mixed bag of opinions there. So we're gonna just leave it at a yes and no for now.
I think that we robustly addressed it, Mary Jo, and it may have been discussed even after you put your comment in. But
Yeah,
there is a
maybe.
mixed bag. Yeah.
Yeah.
They can change their theory. The question is, they can change the theory. The question is whether it's going to be a good idea for them.
Yes.
Yeah.
I do agree with that.
Should Karen take the stand? Thoughts?
No.
From Melissa.
No.
I don't think any attorney worth their salt would recommend that a defendant should take the stand unless you are claiming some form of self-defense. That's the only time.
I think that's pretty accurate, other than to add, like, when it is abundantly clear that your client is the only way to get really relevant evidence in on a particular point, you don't have them testify. It's
Gotcha.
especially with certain prosecutors, but there's enough fodder here. Andrew was saying before, she's innocent, and there's she's factually innocent. There is textbook, in my opinion, definition of reasonable doubt. This is the type of case, because of those pieces, I would never put her on the stand. And in some respects, her getting out there, I can't speak for her, but her getting out there to news outlets, putting her version of, or answering some key questions. And I heard there's another one coming tonight after the Super Bowl.
Yes.
I'm interested, Andrew, to see what that is on Boston 25.
Ted Daniel coming through.
Ted Daniel. But she, in many respects, may be doing that in response to Morrissey getting out there ahead of time and making statements to the public that, in my opinion, have proven to be factually false. So we'll see.
It's just not a good idea, because, you've got a team of attorneys that are going to be listening to what she says, and they're going to
Yep.
be tearing it apart, and they'll be asking the same question 14 times. And if she deviates just a little bit, they'll drive a tractor trailer through it. It's not a good idea.
Yeah. Yeah. Considering especially how much they already have done just from, any element of variation in her verbiage. I mean, unless she rehearses word for word her statement, which would then come off to the public or a jury as a lie because of how rehearsed it would sound. It's just, either way you slice it, you're kind of damned if you do, damned if you don't.
Agreed. You have such good insights on this, Britt.
Oh,
really
thank
do.
you. Thank you, Nan. Thomas is asking, what about Proctor? I think he's referring to Proctor taking the stand. Do you think they'll bring him back?
I think that that's a decision that the prosecution will have to make, or the defense. I would refer people to, I was on a prior stream earlier this week, and I think it was Brian LTL's. It might have been Nurse Kim's or the Young Jerks, where I discussed that. It's a calculated decision. I think it looks really bad if you don't call the lead prosecutor in to testify.
But it's really bad if you do bring him in. I agree.
Yeah.
How do you decide? Either the Commonwealth or the defense is going to call the guy. The guy will be on the stand in the second trial, because it just shows that the whole investigation from day one was tainted. It was rotten. It was pushed by the lead investigator, who was clearly biased against Karen Reed. He just wanted to get her. He said all those things that we're not going to repeat on your show, but we all know what he said. He was a biased, unprofessional boob, and he just, I think
you heard it here first. He was a boob.
I think everybody, I can't imagine anybody in YouTube land that's going to disagree with me. I mean, maybe it was a bad choice of words, but it just shows that the investigation from the ground up was rotten, and the fish rots from the head down, and that's what happened in this case.
And he had his hands in everything. I think they're going to call him, though. I'm predicting it. I think they will.
The Commonwealth or the defense?
I think the Commonwealth will, because they'll be afraid of the optics, and I think the defense won't, or they'll think closely. They're thinking about it, because it's harder to direct a witness like that. It's just going to be harder if they call him on direct. But I think that the prosecution will call him, and I think that will make for must-see TV.
Well, in my opinion, all attorneys are allowed to have their own trial strategy. It's what we do. And if you put 5 different attorneys in a room and give them a mock case, as I've seen happen, you're going to get 5 different views of trial strategy. Lally's strategy was, there's a lot of bad stuff in this case that goes against me. I'm going to go with letting it all hang out here so that I can minimize the damage, because if you hide stuff and let the defense bring it out in their case, that's not good for a jury to say, what were you trying to hide? So that's what they saw. That's what Lally tried in trial 1.0, and it backfired. It didn't go well. So they might reconsider that. I'm not so certain that Mr. Brennan would want to put him on the stand. I might be wrong, but I'm not so certain the Commonwealth would want to put him on the stand the second time.
Probably not.
It's going to be interesting, and if they do or they don't, Andrew, I'm going to reach out to you and say, what do you think? It looks like he testified. I'd be interested to hear your thoughts, or to see them on your show, which I thoroughly enjoy.
Thank you. Well, if the Commonwealth doesn't put him on the stand, the defense will. If I was the defense attorney, isn't it true that you said that she doesn't have this? Isn't it true that you said she's a?
Well, you can't do that. You can't do that, though. Those are leading questions. That's they're gonna have the defense. No offense, I don't mean to.
No, they'll get it in. They'll get it in.
It'll have to be very carefully worded.
Yeah, it will have to.
Otherwise, the objections. Yeah.
Didn't you say this? Yeah.
So, Britt, I apologize to you and Andrew and your
audience. We're out of time. Yep.
I have to pop off.
I know. You got your basketball game. Nan, I so much appreciate you coming. Thank you for your time. Thank you for your generosity. Thank you for being here. I am so excited to have you back. Guys, since Nan's out of time, I'll just tell you right now, we will try to have another Nan Drew show.
We have an acronym. We have a one of those pet names, Andrew.
Yes,
We're
yes.
Nandrew.
Oh my God.
Another
Oh, goodness.
Nandrew show. Yes, the Savage Patch has
Nice to
called
meet
me that.
you.
Nice to meet you too.
Yeah, you
Take
guys
care.
have been so engaging. Thank you both for coming. I'll go ahead and try to close everything off on my own here. Go whatever your son's basketball team is called. We're rooting for him.
Thank you.
And we hope that you both have a wonderful rest of your Super Bowl Sunday. Please come back anytime, either one of you.
I'm
or
looking
both.
forward to
Take
it.
care.
I'll
Thanks.
see you
Take
on
care.
the tubes. Take care.
See you soon. Bye, Nan.
Bye-bye.
Bye, Andrew. Oh man, what an interesting couple of people, right? I mean, that couldn't have gotten any better, any more engaging. I just had an absolute blast listening to both of them. They both have so much wisdom, so much valuable knowledge of very different elements of this case. Oh yeah, Charlie said it best. They are so refreshing. Both of them. I mean, it's so great hearing new voices in this. So, oh, are we really 15 subs away from 800? Okay, y'all. Thank you. Thank you. Thank you. All right. So I'm going to go back through other questions and stuff like that. I know that a lot of your questions were for Nan and Andrew, but maybe they'll go back and see this, and then maybe the next time they come on, we can address them. So yeah, we did talk a little bit about the jury, Jeff. Thank you so much for your question, and by the way, for busting a caps lock to ask. Yeah, it's very, very true, and we've also seen some actions on part of Hank and the defense to, kind of possibly create a preconceived notion in the jury pool. That's why you see, so much hyperbolic language and things anymore. Dennis, thank you so much for your 10. Thank you for helping out this itty bitty baby channel. Try to grow. Indie girl, are you a Hoosier? If you are, we got to talk. Thank you so much for wishing the channel good luck. Brandy, one of our wonderful moderators here, tell the truth and nothing but the truth. Love it. That is going to be, hopefully, once we get to where we can have memberships with the fun emojis, I will totally design a tell the tooth emoji. Raka fraka. That is so fun to say. I could say that 100 times fast. We know the defense issued a demand to press video on 2222 in Stoughton, but we also know Auntie Bev denied the transfer of that motion when the case was transferred to her. I am so going to forward that to Nan and Andrew for you, Raka fraka, and maybe on the next stream, if I've heard back from them, bring that up back for you. Thank you, Raka fraka, and thank you for your 10. Please pass the pepper. And the salt. Thank you for your super sticker. Brandy, that is a great question. That's all I'm going to say. That is a good question. I don't know. They have been so tight-lipped. All I can use to predict future behavior is past behavior, and they have been very, very tight-lipped. But now that he's not, I don't know. I think he's still working for the U.S. Attorney's Office somewhere. I mean, I just don't know what he's doing. Obviously, he's not in the position that he was in, but I don't know where he is now or what he's doing, or if he has signed an NDA. I mean, we have a lot of variables to think about, and we don't know what those variables even are. Okay, pass the pepper. Thank you again for your other soupy sticker. I appreciate it. Should the defense have a Lexus expert testify? Say that 10 times fast. Jeepers creepers. I read an article that there was a safety feature that won't allow it. Okay. What you are referring to, Karen, is the anti-lock brake system. Um, it's basically like a pulsing of your brakes. So if you are reversing really fast, especially in the elements, if you have snow, ice, anything that can affect your traction, your car is going to sense that and try to stop you so that you don't lose control of the car, spin out, flip your vehicle, stuff like that. So, that's an excellent question. If I were an attorney and if I were on Karen's defense team, I 100% would have somebody from Toyota, Lexus come and testify if it were me. Um, all right, guys, we are 6 subscribers away. So if you are lurking, please consider maybe helping me hit a little milestone today. That would be wonderful. Um, Guys, thank you oh so much for being here. I've never had this many little messages in the chat to go through. I normally try to bring everybody up, but there was so much engagement. So many people in here. Thank you oh so very much for coming. Oh, OnlyFans helping a girl out. Okay, love it. Boston Brandy, thank you for being a cheerleader for the channel. Bob, hey, Bob and I met on Nurse Kim's page. I am a mod for Nurse Kim, and she has been on this show. It was on a day where I had horrible internet coverage. It was my maiden voyage on YouTube. It was a complete fucking disaster. I crashed and burned. I lost internet, and it was great though, because during the periods where I was either frozen or completely out, Kim helped me by at least engaging and being herself for just a little bit. Oh, Bob, thank you. Thank you so much. Rocket Frock is a Hoosier. Yeah. Okay. So I was born in Noblesville, just because of where our family was living at the time. But I've got a lot of family up there. I try to go to Indy like once every 2 or 3 years at least, just to see my extended family. But I didn't live there very long. Like right after I was born, we left. Oh my God, did we hit 800? Hello, Kathy's Legs. Welcome. Thank you oh so much for being here. I'm glad that you were able to join, and I'm glad that you were able to watch today, because this was an amazing, amazing stream. Oh, thank you so much. And Scott, thank you for being here today. We had such a blast. I mean, I know I did. Hopefully y'all did. Guys, I want to make sure that we all have enough time to make our Super Bowl snacks. And please don't forget, tonight we are going to hear from Karen. Okay, she is going to be giving an interview with Ted Daniel. He is a journalist for Boston 25. Make sure you watch. As soon as I find a link, I will post it on Twitter X, on my little handle here. If you haven't followed me on Twitter, go ahead and follow me there, and I will make sure that you are provided with a way to watch Karen. Miss Robinson or Mr. Oh, woman. Hello. I'm so glad to have you from Droitwich, the UK. 74-year-old diagnosed autistic woman whose special interest has been true crime all her adult life. She has been obsessed with this case for over 18 months. We are so glad you are here, Miss Robinson. You are in wonderful company. We are so glad to have you. You are one of us already. Glad to have you in the Savage Patch. See, look at all this love coming for you already. More excited for Ted and Karen than the football game. Oh, you and me both. I'm sure you are not the only one, Brandy. Oh yeah. See, Nikki already agrees with you. I think we're all more excited for this interview than for the game. Are you guys rooting for the Birds or for the Chiefs? I'm gonna say the Birds. I mean, I'm a Green Bay fan, so I don't really have a dog in the fight, so to speak, but I'm gonna go Birds. Um, okay, so Kat, it'll be immediately after the Super Bowl. All right, we got some Eagles fans. New Albany. Okay, that is awesome. There's guys, don't sleep on Indiana. Yes, I'm a Packers fan. Don't come at me for it. Oh, okay. So wait, no, you're a cheesehead too. Okay. Very, very good. Okay, we got some Green Bay people in the house. Awesome. So, guys, we are going to be back here. Let's see. Now, this coming Sunday is my grandmother's birthday. She's turning 83 years old. So I'm unsure of whether next Sunday we're going to have a stream because I'd like to give her my time and make the day about her. Maybe something that night. We just don't have anything on the books for that day. However, I have taken the day off for Friday the 21st. And I wanted to mention this to Andrew, but that was definitely a quite a discussion. It was a very energetic discussion, and it went on to other places before I could tell him. So I didn't take the 21st off because of the motion to dismiss that's coming. I took the date off because I'm going to see Bone Thugs and Harmony the night before, and I wanted to sleep in the following day. But once we get this motion to dismiss, we are going to do a stream with Nan. We're going to go through this motion together, and I believe it is going to be one of the most beautiful pieces of legal literature in all of American history. I really do. I think it is going to be so eloquently done. I think Alessi is going to have a hand in its drafting, and I think he is going to tear the Commonwealth a brand new 3-bed, 2-bath, double wide asshole. So I'm so excited to go through that with y'all. So make sure you come back on Friday, the 21st of February. And aside from that, what else is coming up? I need to have a little calendar right here so that we can all see. I would like to hear from you guys with ideas that you of things that you would like to go over. I want to go over Sean Ellis. I want to go over Lucia Roberts. I want to go through all this stuff with you and do kind of like a little bit of blind reading, a little bit of in-depth diving. And then we also have way more just on root stuff to cover. So what I think we'll do the 16th is after we're done having birthday time with Binky, that's what I call my grandmother. Once Binky's done, we will do some just on root material. And then on the 23rd, if you guys are familiar with the YouTube show Calling All Beings, my friend DJ is going to come on and shoot the shit with us. It's going to be great. So please make sure that you're here on the 23rd for that. And then I want to hear some ideas from y'all for emoji once we get memberships activated. I want you guys to have some extremely fun emojis that you would appreciate. So please make sure that you email me. My email is Brit with 2 T's, Brit Happens Channel @gmail.com. Oh yeah, Amy, we love DJ. DJ actually was my introduction into YouTube. I originally am from TikTok. I'm a what you call a TikTok refugee. I originally am from TikTok, moved over to YouTube, and yeah, so DJ really helped me kind of learn the ropes. He brought me onto his show a few times. yes, a TikTok transplant. I like that too. I don't know if I like transplant or refugee better. We'll just kind of bring up both. But yeah, make sure you come back on the 21st, the 23rd, possibly the 16th. 16th would be just on. The 21st will be that glowing motion that we're gonna see, and we'll have Nan back for that. And the 23rd, we will have DJ. And please make sure that you, again, email me with ideas for emojis, cases you'd like to go over. Like Melanie Little says, I can't guarantee that I will respond to your email, but I can guarantee that I will at least see it. So please send your ideas there. Y'all have just been the bomb diggity. I appreciate each and every one of you, all of your generosity. Just your presence has been very much appreciated. This was a fantastic, engaging conversation that we got to have with Nan and with Andrew. Thank you guys for watching. Thank you guys for your questions and for your participation. So I will see you guys very shortly. And I very much look forward to it. I'm going to leave my my other platforms up in a little photo. So if you guys would like to know where else you can find me, I'll leave that up for you here for just a little bit before I shut the stream down. So make sure that you check that out. And I hope you have a great rest of your Super Bowl Sunday. As I say every stream, peace, love, and butt dials. Have a great rest of your day.
We were in the middle of our tournament when my friend John said he found a body in the bushes over there. I ran over there because I'm a healing monk to try and help, but obviously my magic wasn't strong enough because the dude's body was missing a head. So my friend decided to try and use a necromancer spell, which didn't work, which I knew it wouldn't. And apparently we contaminated the crime scene because that spell uses a lot of glitter.
Your Honor, I object!
And why is that, Mr. Reed?
Because it's devastating to my case!
I gotta tell you, you brightened my day, ma'am. All right?
That's what the last guy said, and then he sued me.